Hello viewers, today we will discuss the topic threat to privacy in cyber age, need for an effective wheel. Yes, the concept of privacy is not new to India. The ancient Indian theory of knowledge based on our old literature prescribes meditation which is to be done without any outside disturbances. The policy underlying the rules regulating construction of houses and palaces found in the Grihya Sutra, the Ramayana, the Mahabharata and Arthashastra manifest ample consideration and respect for one's privacy. The use of curtains as described in the Ramayana and other classical literature is pointer in the same direction. In modern times, the right to let alone is being given a fresh thought in view of the invention of new means and methods to outrage one's personal domain. The invention of computers and internet has added fuel to the fire. The anxiety to protect privacy was never as evident as is today. The reason being, now it is possible with the aid of new generation electronic gadgets to collect and disseminate personal information in a flash of seconds anywhere in the world. Then we will discuss what does privacy means. It is one of the most difficult tasks to define the term privacy. Privacy, as the meaning of privacy varies widely depending upon the context and circumstances and the environment. It has been described as the rightful claim of the individual to determine the extent to which he wishes to share of himself with others. It means right to withdraw or to participate as seems fit. It also means that individual's right to control dissemination of information about himself. It is his own personal possession. Privacy has also been defined as a zero relationship between two or more persons in the sense that there is no interaction or communication between them if they so choose. The concept of privacy is used to describe not only right purely in the private domain between individual, also constitutional rights against the state. The former is concerned with the extent to which an individual or a media is entitled to personal information about another individual. The latter is about the extent to which state can intrude into the life of the citizen to keep watch over his movement. Allen F. Weston defined privacy as the claim of individuals, groups, institutions to determine for themselves when, how and to what extent information about them is communicated to others. The technology advancement relating to computer, internet, telecommunication, network has brought the need for privacy and its protection through law to the forefront. Privacy in cyberspace can be described as the desire of every individual for virtual space, where one can be free of interruption and where one can control the time and manner of disclosure of the personal information. What is cyber privacy? Cyber privacy in modern technological innovation and developments in the field of computers and internet have created an environment in which there is inexpensive and ready access to an ever growing pool of personal information about identifiable individuals anywhere in the cyber world. Privacy in the technology driven world is difficult proposition. Technology has become a kind of double-edged sword. One can hand it equips the person to safeguard his privacy, and on the other it helps in blowing the privacy cover one may have. The internet is a rich source of personal information about online potential consumers. Some of the website owners follow the consumers' online activities and gather information about personal liking and disliking. The data so collected is valuable for a web enterprise because not only it is possible to the target market products and services, but on the basis of such data that may also be sell advertising space on their website. The personal information data may be recorded by government departments, various service providers and other organizations like insurance companies, banks, hospitals, schools, credit card companies, telephone service providers, etc. This personal information may be misused if fallen in wrong hands. Mr. Bill Gates, in his book The Road Ahead, has expressed his concern relating to privacy. Loss of privacy is another major worry where the network is concerned. The potential problem is not mere the existence of information, it is the abuse that makes me worry. The surveillance on internet is being done mostly through cookies, web bugs, spamming, hacking and spyware. Now we will briefly discuss these terms. What does cookies mean? A cookie records that preference of the internet user while using a particular site. It is a block of text which the website places in a file on a computer hard disk of a person to track his cyber activity. Most of such websites are affiliated to online advertising services and therefore they indulge in sending customized advertisement. While cookies do have use for both the user and the web provider and are helpful, they can be misused also. It is useful for the user when dealing with a company that has good privacy policy in a place. It might create problems when the collected information is made available to everyone, resulting in leak of some confidential data. The real problem is the aggregation of data from multiple sources, resulting in a user's profile. Collected personal information is now being treated as a commodity belonging to the collectors. Then we will discuss the term web bugs. A web bug or web beacon can be used for a creation of a user's database. It is a file, object, usually a graphic image such as transparent graphics interchange format that is placed on a web page or in an email message to monitor user behaving function. It could be the part of the banner ad on a website's web page that a person is viewing. The embedded instruction would cause the person's browser to transmit to the server of the advertiser the URL of the page person is visiting. Through WebBug, a computer can be subject to search. This is violation of privacy as a computer is the storehouse of a person's most valuable information nowadays. Then we will discuss spamming. Spam is unsolicited email through which a message is delivered over the internet to someone who could not otherwise choose to receive it. Most of the spam is commercial advertising. It also refers to sending an email message to hundreds and thousands of internet users. In no other form of advertisement does the advertiser pay so less as compared to those to whom the advertise is aimed. The receipt of unsolicited commercial electronic mail may result in cost to the recipient who cannot refuse to accept such mail and who incur cost of the storage of such mail or for both. Then we will discuss hacking. Hacking refers to unauthorized access to a computer system. It is one of the most serious cyber crimes with which the internet users, government agencies and the corporate organizations using computers are confronted. A hacker attempts to hack in a remote computer system for various reasons including data theft, eavesdropping, fraud, destruction of data, damaging the computer system, mere fun or personal satisfaction. Hacking could result in violation of individuals' privacy and might cause malicious harm to a network or a computer system. Hacker may steal useful, confidential information stored on a computer like credit card numbers, passwords, etc., that may cause immense financial and personal harm to the user of such computer. Then we will discuss spyware. Spyware is another threat to privacy of an internet user. Some software developers have include code, trojans, backdoors, Santas, adware and drive by downloads etc. with their application that causes the user's computer to transmit information back to the software developer via internet. Spyware can be used for generating annoying pop-up advertisement, collecting password and credit card numbers etc. Then we will discuss whether the right to privacy is a fundamental right. Right to privacy is not specific fundamental right under the Constitution of India. However, the Supreme Court has recognized it by creative interpretation of the right to life and right to freedom. It is noteworthy that right to privacy is one of the most reasonable restriction to the fundamental right to freedom of speech and expression, which is defined in under Article 19 subclause 1A of the Constitution. The fundamental right to life and liberty guaranteed by Article 21 has been interpreted to include right to be let alone. The constitutional right to privacy flowing from Article 21 must, however, be read together with the constitutional right to publish any matter of public interest subject to reasonable restriction. The right to life has been interpreted as right to live with human dignity. It is by the virtue of his dignity that every individual has a right to private life, free of interferences and hindrances. The Supreme Court has developed the right to privacy over a period of time with the help of creative interpretation. In the case of Khadak Singh versus State of UP, Justice Subba Rao in his minority opinion laid the foundation for the development of the right to privacy in India. He held that concept of liberty wider under Article 21 was comprehensive enough to include privacy and that a person's house where he lives with his family is his castle, and nothing is more deleterious to a man's physical happiness and health than a calculating interference with his privacy. In another case of Gobind versus State of Madhya Pradesh, the Supreme Court acknowledged a limited right to privacy and held, assuming that fundamental rights explicitly granted to a citizen have prenumerable zones and that the right to privacy is itself a fundamental right. The fundamental right must be subject to restriction on the basis of compelling public interest. It was further held that privacy dignity claim deserves to be examined with care and to be denied only when an important countervailing interest is shown to the superior. There are many instances where journalists sought to permission from the court to interview and photograph prisoners. In such cases, although privacy issue was not directly dealt with, the court implicitly recognized the right to privacy and held that press has no absolute right to interview or photograph a prisoner. The press must first obtain the consent of the person sought to be interviewed or photographed. In the case of R. Rajagopal versus State of Tamil Nadu, which is commonly known as a Auto Shankar case, is a milestone in the development of law of privacy in India. Here, the court declared the right to privacy is inherent in the right to life and liberty granted to the citizen of this country by Article 21. It is right to be let alone. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing and education among other matters. None can publish anything concerning the above matter without his consent. In the case of People's Union versus Civil Liberty versus Union of India, the Supreme Court held that right to privacy, which was a part of the fundamental right to life, include right to hold telephone conversation in the privacy of one's home or office. Telephone tapping was held to be a form of technological eavesdropping and breaching right to privacy. Yet another dimension was added to right to privacy is Sharda versus Dharampal. The question before the Supreme Court whether a party to divorce proceeding could be compelled to undergo a medical examination if such a direction violates the right to privacy. The court observed where there is no right to privacy specifically conferred by Article 21 of the Constitution of India, and with the extensive interpretation of phrase personal liberty, this right has been read into the Article 21. It cannot be treated as absolute right. What is emphasized is that some limitation on this right have to be imposed, and particularly where two competing interests clash. The court has to reconcile these compelling interests, balancing on the interests involved on the basis of aforesaid judicial decision. One may infer that the individual's right to privacy exists, and if violated, a legal action can be taken. Another one is right to privacy is recognized constitutional right and can be exercised against state invasion. Then the individual's right to be let alone is not an absolute right and may be lawfully taken away by the state under certain compelling circumstances. Then we will discuss international recognition to the right to privacy. The right to privacy has long held a place in the international conventions. The Universal Declaration of Human Rights 1948 specifically protects territorial and communication privacy. Article 12 of the same act read as follows: no one should be subject to arbitrary interference with his privacy, family, home or correspondence, nor to attack on his honor or reputation. Everyone has the right to protection of law against such interference or attacks. In similar word, Article 17 of International Covenant of Civil and Political Rights 1966, to which India is a signatory, also protect privacy. The Council of Europe in 1981 Convention for the Protection of Individual with regard to automatic processing personal data and the Organization for Economic Cooperation Development's guidelines governing the protection of privacy and trans-border flows from personal data set out specific rules covering the handling of electronic data. The rule described personal information of a data that are afforded protection at every step from collection to storage and dissemination. The OECD guidelines were drafted in 1979 and adopted in 1980 in the form of recommendation to countries to adopt good data protection practices so that unnecessary restriction on trans-border data flows can be prevented. Then we will discuss the protection of privacy under Information Technology Act 2000. In order to provide legal recognition for transaction carried out by means of electronic data interchange and other means of electronic communication, and also to give effect to the modern law on electronic commerce adopted by the UN Commission on International Trade Law, Indian Parliament has passed Information Technology Act 2000. The IT Act, though not designed to deal with the issue of privacy directly, contains few provisions having bearing on the right to privacy. Section 43 of the IT Act deals with unauthorized access to computer system can be useful in tackling problems relating to cookies, web bugs, spamming and spyware. It makes liable any person who unauthorizedly accesses a computer, extract data and introduce contaminant. Interestingly, The penalty for damaging computer or computer system under section 43 is limited to the damages by way of compensation not exceeding 1 crore rupees to the affected person. The IT Act makes hacking a punishable offence. A person guilty of committing the offence of hacking is liable to be punished with imprisonment up to 3 years or with fine, which may extend to 2 lakh rupees or with both. Hacking of a protected system is punishable under section 70 of the IT Act. Any person who accesses or attempts to secure access to protected system in contravention of section 70 is liable to be punished with imprisonment of either description for a term which may extend to 10 years along with fine. The IT Act introduced the concept of cryptography and digital nature. They ensure privacy over the internet, but section 69 subclause 1 of the IT Act authorized the controller to order or direct any agency of the government to intercept any information transmitted through any computer resource. The controller can do so only in such situation where he is satisfied that it is necessary or expedient in the interest of the sovereignty or integrity of India, the security of the state, friendly relations with foreign states, or public order for preventing incitement to the commission of any cognizable offence. It is submitted that right to transmit an encrypted message can be viewed as a right protected under right to privacy. Emanating from Article 21 of the Constitution, the IT Act leaves complete discretion in the hands of the controller and therefore give rise to a genuine doubt whether the procedure given under this section will pass the test of reasonable, just and fair procedure. Section 72 of the IT Act deals with confidentiality and privacy of individual. Any person who has secured access to any electronic record, book, register, correspondence information, document or other material without the consent of the person concerned is liable to be punished with imprisonment for a term which may extend to 2 years or with fine up to 1 lakh rupees or with both. In case he disclosed such material to any other person, the idea behind this provision, it seems, is that person who has secured access to any such information cannot get unfair advantage by disclosing it to the others without getting the consent of the concerned person. The scope of the selection is narrow as it is targeted only towards the person empowered under the Act. Then we will discuss the punishment for disclosure of information in breach of lawful contract, which is added under section 72A by the Information Technology Amendment 2008. Save as otherwise provided in this act or any other law for the time being in force, any person including an intermediary who while providing services under the term of lawful contract has secured access to any material containing personal information about another person with intent to cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person concerned or in breach of lawful contract such material to any other person shall be punished with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or with both. It is inserted under Amendment of Information Technology Act 2008. In concluding remarks, I must say, in the age of computers and the information technology, privacy has taken a backseat. The concept of privacy is age-old, but the technology has brought information revolution which is posing direct threat to the right to privacy. Keeping balance between the right of individual to be let alone and the fundamental right to information is an important task. The present legal system in India is not fully equipped to tackle this new situation. So far, the law relating to right to privacy has been relegated to the numeral status as is still going through the stage of infancy. It is high time that the government and information technology industry come together to chalk out ways and means to curb the problem of intrusion of privacy. Our legislature must focus upon the enactment of laws to protect privacy rather than laws that facilitate violation of individuals' privacy in the name of governmental functions. Thank you viewers for watching this program.